Hi guys, welcome back. I hope you found the last few revision videos useful. If you haven't already seen them, I recommend you do so. Links are in the description. The following covers Paper 3, Section A, the nature of law. So without further ado, let's begin. The first major topic that comes up is law and morality. So morals are a set of beliefs and values. Now, Philip Harris defines them as principles affecting standards of behaviour. Features of morals are that they change over time. They're not shared by all members of society. Also, many morals are based on the dominant religion in society. So, for example, we've got thou shalt not kill. Laws, they're a set of rules recognised and applied by the state. John Austin defines them as a command made by a sovereign power. Features of laws is that you can pinpoint the day when they're actually created. So, for example, the Theft Act 1968 was commenced on the 1st of January 1969. Starting off with the definitions, morals are a set of beliefs and values. Philip Harris gave them the definition of principles affecting standards of behaviour. So, features of morals are that they change over time and they're not shared by all members of society. Many morals are also based on the dominant religion in society. So, for example, thou shalt not kill, reflecting the law on murder. Laws, on the other hand, are a set of rules recognised and applied by the state. John Austin defined them as a command made by a sovereign power. Features of laws is that you can pinpoint the day they were created, like the Theft Act 68. It's becoming increasingly difficult for the law to enforce morality. Now, this is another paragraph in this essay. So, parliaments struggle to pass laws that reflect morals and beliefs of everyone in society. So, Durkheim said to support this, in small societies, it was possible for there to be common morality and therefore common laws. However, in modern society, people have different morals based on social status, income, ethnicity, religion. This is because nowadays we live in a pluralistic society which contains a wide range of moral standards and values. So essentially, it's hard to please everyone. Private members' bills. So these are used to pass controversial laws like the Abortion Act to avoid parties revealing their controversial views on issues. This allows Parliament to keep up with or, or to keep laws up to date, essentially. Moving on, many academics have tackled the issue of whether laws should enforce morals. So you've got Devlin, who took a paternalistic approach. He said the law should set the basic standard of morality and that society should aim for high standards. Devlin reacted to the Wolfenden Report 1957, which, by the way, led to the legalisation of homosexuality in the Sex Offences Act 1967. He was very critical and thought there should be a shared morality in society, and that society may disintegrate if morals were not upheld. On the other hand, you've got Professor Hart, who disagreed with Devlin. He was influenced by the utilitarian approach of J.S. Mill. Both thought a minority in society should not be made to conform to the will of the majority. Hart went further. He said the law shouldn't enforce morality, as it would infringe a person's autonomy, describing such interference as unnecessary, undesirable, and unacceptable. Another issue is that there's been cases where one party holds a religious viewpoint that courts don't necessarily agree with. So, for example, this was shown in RE versus A, where confined twins were separated against their parents' will, and in RE vs, where a pregnant woman had a cesarean against her will to save their baby. So these decisions are controversial as the judge is making a moral decision. and it's criticised as uh, they're out of touch and from narrow social backgrounds and old, so their morals may be different from the general public's. So this was kind of shown in Brown, it could be argued, where they didn't really, they were quite biased against homosexual men in this case. However, it could be also argued the decision was not based on sexual orientation, rather that the court didn't want to endorse cruelty and degradation. Looking at some more specific perspectives on law and morality. Firstly, you've got natural law theories. So you've got St. Thomas Aquinas, who believed the law and morals came from God. Since secularization, Fuller, adding on to Aquinas's perspective, argued that a valid legal system had 8 requirements, including that it is in existence, published, understandable, and consistent. Now, on the other side, you've got positivists like Bentham, who criticise natural law theories for confusing legal issues and moral issues. Now, this disagreement was seen in the Hart v Fuller debate. So, this was when laws made by the German government during the war were still valid. Although immoral, they were legally enforceable, according to Hart. However, Fuller took a different approach. He said laws went against natural law, and that as they were immoral, they were never actually valid, and the German courts actually agreed with that. So they prosecuted informants as war criminals, even though what they had done during the war was legal. To conclude, the law does try to enforce morality in many cases, but morals are constantly changing with each generation, so the law sometimes fails to keep up. There can be a there cannot be a complete separation between laws and morals, as many are intertwined. For example, the Human Rights Act of '98 shows law enforcing the rights and freedoms of individuals. Now, what causes conflict is when the law tries to force its idea of morality on a pluralist society. To conclude, the law does try to enforce morality in many cases, but morals are constantly changing with each generation, and the law sometimes fails to keep up. There cannot be a complete separation also between law and morals, as many are intertwined, like the HRA 1998. What causes conflict is when the law tries to force its idea of morality on a pluralist society. Moving on to the next topic, law and justice. Justice is the idea of fairness, or by dictionary definition, just behaviour or treatment. The law, as already mentioned, is a command made by a sovereign power. And fairness, Paramount suggested it can mean many things, to each according to his needs or merits, works, rank, legal entitlement. Now, there are different types of justice, as suggested. You've got distributive. Aristotle says this is the fair allocation of benefits. Substantive. The content of the law must be just. So R.V. Inglis. Procedural. Making and implementing decisions according to the fair process. For example, the Legal Aid Sentencing and Punishment of Offenders Act to reduce the availability of free legal aid representation in a number of civil areas, with many deeming this an unfair process. And you've also got corrective justice, which is essentially restorative justice. So, for example, in sentencing, a number of mitigating and aggravating factors are considered. Now, there are several specific theories about justice. So, starting with Aristotle, he identified 2 types of justice. Distributive justice is the allocation of wealth and assets, such as wealth and honour, in a proportionate way, not based on equal shares, but based on the contribution made by each individual. His second type was corrective justice, which applies when distributive justice is interrupted by wrongdoing and involves punishing the offender and giving compensation to the victim. Taking a similar approach to Aristotle, John Rawls believed that justice could only be achieved by placing people in the original position behind a vow of ignorance. Uh, he basically develops Aristotle's theory by saying a system chosen by these people would be in the system they were creating. So this would work well as people are given and afforded their basic human rights in accordance with the ECHR. On the other hand, Karl Marx believed it was impossible for a capitalist society to have any of these liberties and features that would make it so-called just, because laws are made to uphold the interests of the ruling class. Lastly, although taking the same meritocratic approach as Rawls and Aristotle, Nozick criticises Marx as the redistribution of wealth would only be unfair for those who've worked hard for it. So forth society could only be just if people were free to enjoy their wealth without state interference, so for example tax. It could also be argued that the position in Britain fulfills the criteria that Rawls sets out, at least in respect of guaranteeing fundamental rights and freedoms. Both the rule of law and natural justice operate, and any decisions of government can be challenged through judicial review conducted by an independent and impartial judiciary. Basic rights are safeguarded by the HRA 98, and there are many examples of the government losing human rights cases to illustrate this. So, like UK v Pinochet. This shows the system allows for mistakes to be put right and injustices corrected. However, although substantive justice is achieved, because the basic rules are fundamentally fair, there are many examples where there appears to be a lack of procedural justice. The most famous, probably, case is Stephen Lawrence. While the rules may be fair, they are not always implemented fairly. So, in the case of Stephen Lawrence, two men were arrested 10 years after they committed the crime of a racially motivated murder uh, and a gang attack. But many of the gang still escaped justice. There was issues with procedure throughout. For example, at the start of the arrest, they actually arrested his friend who was with him on the night with no evidence. This led to an inquiry, the McPherson report, that highlighted institutional racism in the police force and also exposed senior police officers obstructing justice. Now, this wasn't the first time that the CJS has shown a lack of justice, as seen in other famous miscarriages in the 1980s, like the Bridgewater Four, the Birmingham Six, involving the IRA in both cases, highlighting discrimination issues. Although those prosecuted spent years in prison, one even died actually in prison in the Bridgewater Four case. Appeals were eventually successful due to a lack of evidence or lack of due process by the courts, helped by the CCRC. This shows corrective justice in play. It's not just the CGS that have shown difficulty in ensuring justice. This has also been the case with juries, where there's been a corrective justice struggle. They uphold features of democracy, so a fair trial, for example, which allows people to exercise independent justice without fear of state interference. You've also got jury equity, case Ponting, who leaked state secrets about the Falklands. However, as the Roskill Commission highlighted, when it comes down to complex cases like fraud, wrong decisions may result, causing injustice. Also, jury nobbling, twomey, and jury prejudices that make some trials unfair, meaning the law cannot perform its duty of restoring imbalance that has occurred between two individuals or an individual and the state. To conclude, the appeals system is often cited as a good example of the guardian of both procedural and substantive justice in criminal and civil law, as it enables those who do not believe justice has been achieved to pursue further action. However, it could be argued that in reality, it's not easy for every litigant and victim of a miscarriage of justice case to access. You've got public funding for many aspects of this is limited, and the CCRC seems to be struggling under an increased workload and is referring as a result of fewer cases than ever in its history. Even if also a conviction is quashed, the appellant is unlikely to be paid any compensation. A society is a group of people with common territory, interaction, and culture. The same society usually shares aspects of this culture, so like language, values, beliefs, behaviour. In fact, the UK is a pluralistic society due to immigration within the British Empire and the Commonwealth. Also, you've got like the Romans, the Norman conquest throughout history. Uh, Religious intolerance, or no, tolerance, in fact, has supported this, but some beliefs offend and sometimes immigrants give up their traditions to fit in. This is what's known as assimilation. Therefore, the UK is a multicultural society. However, prejudice and discrimination keep many groups out of the political process or prevent free expression of beliefs. To protect people against this unfair use of power by the state or others, a legal system requires clear laws and guidelines, stronger enforcement structures, and an independent judiciary. Moving on, Durkheim said the law is a boundary maintenance device with two purposes that he identified: to define sanctions and to prescribe punishment. So he said, uh, as it does this, the law maintains social stability. So there's two types of legal structure, uh, repressive and restrictive. So society can shape the law by protest and strikes. Uh, a threat from a small section of society are often exaggerated by the media to increase sales and profit through sensationalism. For example, the 2011 Sarah's Law, campaigns for child protection, supported by the 2000 by an attack by vigilantes who confused a paediatrician doctor with paedophiles. It allows parents to ask police for relevant information, however. The law can shape social norms and behaviour. So you've got drink driving laws affected society's view of that behaviour, but this is rare. Formal social control occurs through the legal system. So you've got like the police, judiciary, prison service. Roscoe Pound said in 1942 that the content of the law is the elements of human nature which need social control to support individual expectations. So, like a party at fault should be punished, so theft conviction results in a custodial sentence. Another thing is that if the law is weak or inconsistent, it loses its influence and eventually the law may be changed. So, you've got the law on homosexuality that was enforced consistently and did not necessarily follow the views of society on sexual conduct between consenting males. In 1967, however, influenced by the Wolfenden Report, consensual sex between consenting adult males was made legal. Another example of society's views affecting the legal system is in the principle of being tried by one's peers. The jury system was to represent the reasonable men, as women and children were not considered reasonable, so only men were allowed on a jury. Due to pressure from society, this led to a change in values and was changed by the Sex Disqualification Removal Act 1919, as society's views had changed and so the legal system had to follow. So women could sit on a jury. Suicide is no longer a crime, but aiding it is, with a maximum of 14 years sentence, showing confusion in the law. PS policy on aiding suicide is to prosecute unless, for example, the victim made a voluntary informed decision to end their life. Some famous cases, one that I've picked out is Debbie Purdy, who had MS and claimed it was against her human rights to not be reassured her husband wouldn't be prosecuted. This is if he aided her to go to a country where euthanasia is illegal. In 2009, the House of Lords said clarification was needed as to when a person would be prosecuted for an assisted suicide, and the CPS guidelines were drawn up in 2010 and updated in 2014. The defence of consent has also created difficulties for law enforcing control. So you've got Brown, who the judge for that, Lord Templeman, spoke of the need to balance issues of policy and public interest. While in R.V. Wilson, Lord Mustill supported the rights of the individual to live as they wished. Now, this emphasises the inconsistent social control by courts. Like, the application of society's views is basically a subjective decision based on the views of the particular judge in control of the court at the time. To conclude, the law and society are linked. Society's views slowly change and affect the law. A wider selection of magistrates is an attempt by the legal system to better represent society. However, overall, the relationship between law and society is generally effective in protecting vulnerable victims or individuals, and also in dealing with the complexities caused by a pluralistic society. Moving on to the last topic, which is law and technology. Technology is the machinery and equipment developed from the application of scientific knowledge. So new forms are constantly being developed. So, for example, you've got automated systems. Physical records are now kept digitally. Traditional legal rules and principles are not always adequate in these situations. There's quite a few novel situations in this modern era where the law hasn't faced to this extent before. Cybercrime is the increasing hacking into computers to illegally obtain private confidential data. This actually resulted in the Computer Misuse Act 1990, which covers unauthorized access and with intent to commit or facilitate crime. It could be said it's an effective statute as it covers a wide range of illegal conduct involving technology. The issue, however, is that tracing and prosecution of those responsible, as it's quite hard to on the computer, and the failure to keep abreast of new types of cybercrime. Identity fraud. So this is when D uses another's data without consent to deceive another. The issue here is determining in which jurisdiction the offence has taken place, so the victim's or the D's country. As a result, it's unclear which law will apply to the scenario. Data protection. Corporations and institutions all store clients, customers, and staff info on their databases. So this includes everything from their credit history to previous convictions. There's a high risk, actually, of data being accessed unlawfully and or used for fraudulent purposes. Now, to sort of combat this, recently there's been a new act introduced called the General Data Protection Regulation, or GDPR, European Directive 2016, which replaced the Data Protection Directive 95/46 EC in 2018 as the primary law, regulating how companies protect EU citizens' personal data. So companies must ensure that they are compliant with all these new requirements, and if they fall short to these requirements, they're subject to fines or penalties. Companies also may be required to make specified improvements by deadlines, or to order data to be erased, and companies may be blocked from transferring data to other countries. It's beneficial to all, as the same standard is applied throughout the EU, giving consumer wide protection. The GDPR, simply put, enforces a baseline set of standards for companies that handle EU citizens' data to better safeguard the processing and movement of citizens' data. And in comparison to old directive, there's penalties for non-compliance. So that means it's better. So some of the more specific things that you're going to want to mention in the exam is CCTV. Evidence suggests it helps identify crime and those involved. It's useful in tracking terrorists and acts as a deterrent to crime in public areas. You've got the Internet Eyes website, which pays the public to watch CCTV footage from their homes and report to the police. However, this has received criticism from civil liberty groups who say they're part of a state operation. Also, there's issues of who keeps the recorded information and for how long, and what are the limits of its use. So the law here is generally very unclear. Also, another thing, the current question is whether facial recognition should be legally used by police forces in the UK. So for the system, it's easier to identify. So hood wearers are no longer anonymous. A police photo, or they photo those in custody and compare to previous images. So this supports catching and prosecution of repeat offenders. However, there's quite a wide concern as to whether the police will use this to invade people's privacy. So that's kind of like the main sticking point there. A example of this, or an example for this, is that the Ed Bridges case, whose face was scanned while stopping during a testing trial. So civil rights groups claim the current use of facial recognition is equivalent to the unregulated taking of DNA or fingerprints without consent, and therefore breaches HR. However, in September 2019, Lord Justice Haddon Kerr, sitting with Mr. Justice Swift, concluded the police's use of live facial recognition met the requirements of the Human Rights Act. Judges also ruled existing data protection law offered sufficient safeguards for the public, whose faces were scanned by facial recognition cameras, and that the South Wales police had considered the implications. For a short conclusion, it would seem that for all the new developments in technology, the law is trying to take reasonable and appropriate steps to create and enforce legal rules in these respects. Now that brings us to the end of section A for paper 3. One last sort of note from me. One thing to take away from this video is that, well, I recommend remembering these essays, as like my law teacher said, you can pretty much guarantee yourself high marks if you put the effort in, as there's not many you really have to remember. I've tried to split each paragraph or section, if you like, into their own separate slides. So I hope the way I've done it helps in this regard in making it clearer. Yeah, if you've got any questions, just leave a comment and I'll try and get back to you. Anyway, thanks for listening. Goodbye. Judges also ruled existing data protection law offered sufficient safeguards for the public, whose faces were scanned by facial recognition cameras, and that the South Wales Police Department had considered the implications. To conclude, it would seem that for all the new developments in technology, the law is trying to take reasonable and appropriate steps to create and enforce legal rules in these respects. Now, this brings us to the end of section A for paper 3. One last sort of note from me, or one thing that I'd take away from this video is that, well, I recommend remembering these essays, as like my law teacher said, you can pretty much guarantee yourself high marks if you put the effort in, and there's not many you really have to remember. I think there's 4, So I tried to split each paragraph or section, if you like, into these separate slides for each one. So I hope the way I've done it helps in this regard in making it a bit clearer. Also, if you've got any questions, just leave a comment and I'll try and get back to you. Anyway, thanks for listening, and I'll see you in the next video.